This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to this deep dive. We've pulled together some really interesting sources today. We're going to unpack the world of UK startup funding, specifically looking at, simple agreements for future equity safeties and their key UK adaptation, the ASA, or Advanced Subscription Agreement.
Exactly. And this is crucial stuff if you're working with UK startups or, advising clients perhaps from Luxembourg who are interacting with that UK market.
Absolutely. So our goal today is pretty clear. Cut through the jargon, give you a solid understanding of how these ASAs work legally, the tax side, which is huge, the paperwork, negotiations, costs, timelines, the works.
And we'll also try to compare them a bit to instruments maybe more familiar in continental Europe, like convertible loan notes, just to give that context.
Okay, let's jump right in. What's the basic idea here? Where did these come from?
Well, the concept started in the US, really popularized by Y Combinator with the SAFE. The core idea, speed and simplicity for early stage funding. An investor puts money in now.
But gets the equity later.
Precisely. Usually when the company does a bigger priced funding round down the line, it cleverly sidesteps needing an exact valuation right at the start.
Which is often really hard for those very early companies.
Exactly. So the UK version, the ASA, builds on that Advanced Subscription Agreement. The investor is basically prepaying for shares.
Prepaying.
Okay. Yeah, and those shares get issued later, typically triggered by a qualifying round. So that next big funding round, or if that doesn't happen, by a set long stop date.
Right. I've heard of Seedfast too. That's Seed Legal's brand for it.
That's right. Same underlying instrument.
Got it. So deferring valuation, getting cash in quickly. But you mentioned a key UK twist, especially for certain investors.
Yes. This is really the heart of it for UK ASAs. If they're set up to be compatible with the UK's tax relief schemes, CES and ESAs, they are treated quite differently. They're essentially equity from day one.
Pure equity. So not debt that converts.
Correct. The money is an advance payment for shares. It absolutely cannot be repaid as cash. Conversion to equity isn't optional, it's mandatory.
That's a massive difference from, say, a typical loan note.
Huge. And it fundamentally shapes how they work in the UK.
So why? Why structure them this way? Why are they so common in the UK market?
Well, the speed and flexibility are definitely appealing. It's faster than a full-priced round, lets companies raise maybe on a rolling basis. And avoiding that early valuation argument is attractive, no doubt.
But there's more to it. Something driving that specific structure.
Oh, absolutely. The number one reason, the biggest driver for how UK ASAs are structured is compatibility with CES and ASC.
The Seed Enterprise Investment Scheme and the Enterprise Investment Scheme.
Exactly. These government schemes offer very significant tax breaks to individuals investing in smaller, riskier UK companies. So if a startup wants to attract UK angel investors, complying with CSSF rules is basically essential.
And a standard convertible loan note wouldn't usually work for that?
Generally, no. The debt characteristics, potential repayment, interest clash with the equity at risk requirements of CES and EAs.
So the tax rules are literally dictating the legal form of the ASA.
That's a perfect way to put it. The tax tail is definitely wagging the legal dog here. So while the aim is simplicity compared to a priced round, layering on CSSF compliance adds its own specific, often non-negotiable complexities.
Right. Still advantages like getting capital, hitting milestones.
Of course. But founders need to consider the dilution later, and investors always face the risk the company doesn't make it to conversion.
So who's typically using ASAs?
Primarily early-stage UK startups. Think pre-seed, seed stage, maybe bridge funding between larger rounds. The investors are often UK angels, smaller VCs, individuals really drawn by those CSSF benefits.
You might see US investors too.
Yes. Sometimes US investors familiar with SAFES will invest using UK ASA documents, perhaps slightly adapted.
And how do they function legally in the UK?
They're drafted under UK law, specifically considering the Companies Act 2006, structured as that equity, prepayment, no interest, no cash repayment option to meet CSSF. Often drafted carefully, too, to try and fall outside the stricter financial promotion rules under FSMA, especially when dealing with sophisticated investors.
Where and when are we most likely to see them?
Predominantly in the UK early stage scene, pre-Series A funding, bridge rounds. It's become a very standard tool for that initial external capital injection.
Okay, now let's really zero in on what makes UK ASAs tick. And this is vital if you're advising clients interacting with this market from, say, Luxembourg. It's those tax schemes.
Let's touch on them.
But let's get into the detail. What exactly are they?
So, they're UK government initiatives designed to boost investment into smaller, higher-risk trading companies. The carrot is substantial tax relief for individual UK investors who subscribe for new shares in these companies.
Sounds very appealing. Who qualifies? Is it complex?
There are rules for both sides. The investor generally needs to be a UK taxpayer for the income tax relief. Usually, they can't be an employee, though directors have some exceptions, and a big one. The investor, plus their associates, can't control more than 30% of the company.
And the company itself, what does it need to look like?
Key point for your audience. It needs a permanent establishment in the UK. It must be unquoted, though. AIM or AQS listings are okay. Can't be controlled by another company, can't control non-qualifying subsidiaries, and crucially, it must conduct a qualifying trade.
Qualifying trade. What's not included?
HMRC lists excluded activities. Things like banking, insurance, legal services, accountancy, property development, farming, forestry, energy generation. Basically, activities considered lower risk or asset-backed, or where other reliefs might apply. It has to be a genuine trading business. And then there are size and age limits, different for SICE and ICE. SICE is for the really early stage.
Okay.
Trading less than 3 years, that actually went up from 2 years in April 2023. Gross assets must be under £350,000 before the C shares are issued, fewer than 25 employees, and a lifetime limit of £250,000 in SICE funding per company that also increased from 150K.
So SICE is for the very start. ES is the next step up.
Exactly. ES typically applies within 7 years of the company's first commercial sale, or 10 years if it's a knowledge-intensive company, or KIC. Gross assets under £15 million before the EI investment, and $16 million immediately after, fewer than 250 employees, or 500 for KICs.
Okay.
There's also an annual funding limit of £5 million from all these state aid risk finance schemes, combined EIC, Cs, VCTs, and a total lifetime limit of $12 million, or $20 million for KICs.
Those are quite specific thresholds. Let's circle back to the benefits. Why are they so compelling that they dictate ASA terms?
It's the sheer value. CIS offers 50% income tax relief on investments up to £200,000 a year that recently doubled from £100K. If you hold the shares for 3 years and claim the relief, any capital gain is completely tax-free. CGT exemption.
50% back on your investment plus tax-free growth.
Yeah.
Wow.
It's powerful. Plus loss relief. If things go wrong, you can offset the loss against income or capital gains. And there's CGT reinvestment relief, too.
And EIS, still strong.
Very. 30% income tax relief up to £1 million invested per year, or £2 million if at least £1 is in KICs. Same CGT exemption after 3 years. EIS also offers CGT deferral relief. You can defer a gain from selling something else by investing it into EIS. Plus loss relief.
And inheritance tax.
For both, if the shares qualify for business property relief BPR and are held for 2 years, they can be 100% free of inheritance tax.
So the bottom line for ASAs.
The bottom line is, these reliefs are so attractive that UK angel investors often require CESIA or EIS compliance. Startups need to structure their ASAs to meet HMRC's rules if they want that angel money. It's market defining.
Timing matters too, you said. When does the relief actually kick in?
Crucially important. The investor pays when the ASA is signed, but the tax relief eligibility is tied to the date the shares are issued on conversion, not the funding date. Though investors can often carry back the income tax relief to the previous tax year.
And that 6-month long stop date we keep mentioning, how does that timing constraint arise?
Yes. This comes from HMRC's guidance, particularly around advance assurance. They generally expect the ASA to convert within 6 months. Their thinking is that the company's situation, its eligibility, could change significantly over a longer period, making their initial assessment less reliable. So that 6-month expectation becomes a de facto rule for CIS's ASAs needing AA.
What happens after the shares are finally issued?
The company waits until it's been trading for 4 months post-share issue, or has spent 70% of the funds raised. Then it submits a compliance statement in Size 1 or IS1 form to HMRC. If HMRC agrees everything's in order, they issue certificates, say IS3 or EIS3, which the investors then use to formally claim their tax relief. Okay, let's drill down into the specific conditions an ASA must meet for CISs. This is where the tax rules really bite into the legal drafting, vital for anyone advising on these.
Right. What's the first big hurdle?
It's called the risk to capital condition, introduced in 2018. It's not just, is this a risky startup? HMRC looks deeper. Does the company have genuine objectives to grow and develop long term? And, crucially, does the investment itself carry a significant risk that the investor could lose more capital than they gain, including the tax relief?
So it's a gateway test to stop abuse.
Exactly. It filters out low-risk capital preservation schemes. It's a qualitative assessment by HMRC, looking at the business plan, the market, the potential returns versus the risk.
Makes sense. What else?
The use of funds condition. The money raised must be used wholly for the qualifying trade or related R&D. It has to be spent within 2 years. It must be for the company's growth and development, pose a risk to the investor's capital, and it can't be used, say, to buy another business or shares.
Okay, we've got risk to capital, use of funds, and the 6-month long stop expectation we discussed.
Yes, driven by the AA process. Then come the really crucial prohibited terms, things the ASA cannot include if it wants to be CSSF compliant.
Okay, what can't be in there?
HMRC's guidance is quite clear. The investment must be non-refundable. The ASA cannot provide for repayment of the subscription amount. It cannot accrue interest. And this is a big one. For EIS specifically, the agreement cannot be varied, canceled, or assigned once it's made.
Cannot be varied. That sounds incredibly restrictive for a commercial agreement.
It is. It's a specific EIS constraint that removes flexibility parties might normally expect. And the conversion must be into new, full-risk, ordinary shares.
Ordinary shares. Does that have a specific tax meaning here?
Yes, a very specific one for CSSF. These shares must be fully paid up when issued, and they cannot carry any preferential rights over other ordinary shares regarding dividends, rights on winding up, or redemption.
So no liquidation preferences, no guaranteed dividends, nothing like that if you want the tax relief.
Precisely. The investor must step into the same economic position as existing ordinary shareholders, same downside risk, same upside potential. This is a major difference from typical preference shares you might see in other contexts or non-CSSF convertibles.
Anything else in conditions?
Just to reiterate, the gross assets test, the $350K for CSSF, 15 meters and 16 meters for EIS, that's tested at the time the shares are issued upon conversion, not when the ASA is signed. That's a frequent point of error.
And who oversees all this?
It's all administered by HMRC, His Majesty's Revenue and Customs in the UK.
Okay, so how does this feed into drafting the ASA and getting that advance assurance you mentioned?
Well, drafting means you have to explicitly build in or comply with these conditions. State clearly. Non-refundable, no interest, converts only into qualifying ordinary shares, include a long stop date, usually 6 months. Many templates, like those from seed legals or specialist law firms, are designed around these rules. Then advance assurance, or AA, it's a non-statutory process where HMRC gives an opinion, not a binding guarantee, but an opinion on whether a proposed investment is likely to qualify based on the information the company provides.
Why bother if it's not binding?
Because, practically speaking, most experienced UK angel investors simply will not invest CSSF funds without it. It gives them comfort, it de-risks the tax relief element significantly for them, even if it's not a 100% guarantee.
Right, it's a market requirement. How does a company get it?
The company applies to a specialist unit within HMRC. They submit their business plan, financial projections, the draft ASA terms, details of the shares, evidence they meet all the conditions, and usually evidence that they have investors interested.
And how long does that AA process take?
HMRC aims to respond within a few weeks, but honestly, it can vary a lot. 2 weeks sometimes, but often 1, 2, even 3 months isn't unusual, especially if HMRC has questions or needs more information. This AA processing time is often the real bottleneck in getting an CSSF deal done. Okay, let's switch from the tax rules driving the terms to the actual bundle of documents needed. It's not just the ASA agreement itself, is it? There's more required under UK law.
All right, walk us through that. What's the critical thing to understand here, especially coming from maybe a different legal system?
The critical insight is that just signing the ASA and wiring the money isn't the end of the story. Before the company can legally issue the shares when the ASA converts, specific UK company law formalities must be handled correctly. Getting these wrong can actually invalidate the share issue.
So it's about the corporate plumbing before conversion. What documents are we talking about?
Well, obviously the ASA agreement itself, the contract between the company and the investor laying out the amount, cap, discount, long stop, etc. But then you need the supporting corporate documents, mainly governed by the Companies Act 2006. First up, board resolutions. The directors need to formally approve entering into the ASA, authorize someone to sign it, and crucially approve the future allotment of the shares when conversion happens. It's basic director duties and corporate governance, recorded in board minutes.
Makes sense. Then the shareholder resolutions. These often feel different compared to civil law systems.
They are, and they're vital. Two key ones usually. First is the authority to allot shares. This is under Section 551 of the Companies Act. Directors don't automatically have the power to issue new shares. They need permission from shareholders.
How do they get that?
It can be in the company's articles of association or granted by an ordinary resolution that's just a simple majority vote of shareholders. This authority specifies a maximum number of shares and has an expiry date, usually up to 5 years. It must be in place before the shares are actually allotted at conversion.
Okay, authority to allot. What's the second one? The trickier one.
Disapplication of preemption rights. This is sections 569 to 571. UK law automatically gives existing shareholders a right called preemption rights, section 561, to be offered any new shares issued for cash first, in proportion to their current holdings.
So they get first dibs.
Exactly, which obviously doesn't work when you're bringing in a new investor via an ASA. So you need to get the existing shareholders to agree to waive or disapply this right for the specific shares being issued to the ASA investor.
How is that done?
For a private company issuing shares for cash, disapplying preemption rights typically requires a special resolution. That needs a higher threshold, at least 75% of shareholders voting in favor.
So 75% approval needed just to let the new investor in without offering shares to everyone else first.
In many common scenarios, yes. It's a key shareholder protection under UK law and a significant procedural step. This disapplication resolution also needs to be passed before the shares are allotted at conversion. Failure here is a major compliance issue. You might also need to update the company's articles, say if you were creating a new share class for the conversion, though less common for FICI's ASAs converting to standard ordinary shares. Amending articles also needs a special resolution, 75%.
And after conversion happens, what then?
Once the shares are actually issued, the company has administrative tasks. It must update its internal statutory books, especially the Register of Members. And within 1 month, it has to file a Form SH01, which is a return of allotment, with Companies House, the UK's company registry. That keeps the public record straight.
Okay, that covers the company side. Any specific paperwork for the investor?
Yes, particularly for CSSF. The company needs the investor to provide certain declarations or information. Things confirming they're a UK taxpayer, confirming they aren't connected to the company in a way that disqualifies them from the relief. This helps the company with its HMRC compliance filings later. It might be built into the ASA or requested separately.
And something about financial regulations, too.
Right. Investor sophistication declarations. This relates to UK financial promotion rules under FSMA. If the company isn't FCA authorized and isn't using an authorized firm to promote the investment, it usually relies on exemptions. To use these, the investor often needs to self-certify that they meet certain criteria like being a high net worth individual or a certified sophisticated investor.
Right.
It's basically the company protecting itself, showing it's only promoting the investment to people who are considered experienced enough to understand the risks, rather than illegally promoting to the general public. This declaration is often signed alongside the ASA.
That's quite a checklist. So the ASA is just one piece of a larger procedural puzzle.
Exactly. It's the commercial agreement, but making it legally effective involves navigating these specific UK company law requirements. Getting the formalities right is absolutely crucial. Now, we said ASAs aim for simplicity by pushing the valuation discussion down the road, but that doesn't mean nothing is negotiated up front, right?
Yeah. Good point. So even with standard documents, there's still key terms up for grabs. What are the usual negotiation points?
Well, yes. The big economic terms are nearly always discussed. The valuation cap is a major one. Is there a cap? And if so, at what level? The cap protects the early investor if the next round valuation is very high. Founders prefer high caps or none. Investors want lower caps.
And the discount.
The discount rate, exactly. This gives the ASA investor shares at, say, a 10% or 20% discount to the price paid by investors in the next qualifying round. It rewards their early risk. Investors push for higher discounts, founders for lower. Data, like from Seed Legal, suggests maybe half of ASAs have caps, and common discounts are often around 0% or 20%. 0% might happen if the cap is very favorable, or maybe for insiders.
What else gets negotiated?
The long stop date, how long before conversion happens automatically if there's no qualifying round, and sometimes a specific valuation if conversion happens at the long stop. Also, the definition of that qualifying round, how much money needs to be raised to trigger the conversion. Minimum thresholds matter.
Any other investor protections?
Investors might ask for an MFN clause, most favored nation. That means if the company later issues another ASA on better terms, the earlier investor automatically gets those better terms too. Pro rata rights are another possibility, the right to invest more money in future rounds to maintain their percentage stake. Less common for small angels, more likely for VCs. And sometimes for larger checks, information rights, or even board observer rights.
So who are the parties usually pushing and pulling on these terms?
You've got the company, represented by the founders, obviously wanting to raise the funds but minimize dilution and keep control. So they'll argue for founder-friendly terms like high caps, low discounts. Then you have the investors, wanting to maximize their potential return for the risk they're taking. They'll argue for lower caps, higher discounts, maybe those MFN or pro rata rights. And remember, for UK investors focused on CSSF, the core compliance aspects, non-refundable, no interest, ordinary shares, those are generally not negotiable. They have to be there for the tax relief.
How do these points usually get settled in the UK market? Is there a standard?
There are definitely market norms, particularly for caps and discounts in specific sectors or stages. The 6-month long stop for CSSF is heavily influenced by the AA process, so less room to negotiate there. MFN clauses might be given if the company intends to keep terms consistent anyway, but they can add admin complexity. Pro rata is less standard for early ASAs. The CSSF framework itself locks down certain terms, and the rise of legal tech platforms has also pushed towards standardization, often focusing the negotiation sharply on just the cap and discount.
When does this negotiation happen?
Typically right at the start, before the ASA document is even drafted. Sometimes there's a short-term sheet outlining the key points, especially if there's a lead investor. It all happens within that UK startup funding environment. Which brings us to a practical point. Costs. ASAs are often described as cheaper than priced rounds, but what does that actually mean? What are the costs involved?
Right. Cheaper up front, you said. What kind of costs are we looking at?
Generally, yes, the upfront cost is lower. The main expense is legal fees. For the company, this covers drafting the ASA itself, preparing those essential corporate documents, board minutes, shareholder resolutions, and any lawyer time spent negotiating or reviewing terms with investors.
And why is it cheaper than a priced round?
Primarily because you're deferring the really complex, time-consuming parts. Setting a precise valuation, extensive due diligence by investors, and drafting much more detailed documents like a full shareholders agreement and amended articles of association with investor rights. ASAs skip or postpone much of that.
Any ballpark figures for these legal fees?
Sources suggest quite a range. Using a legal tech platform like Seed Legals for a straightforward ASA might cost the company somewhere between, say, £500 and £1,500. If you use a traditional law firm, especially for something more bespoke or with multiple investors, you could be looking at £1,500 to £5,000 or potentially more. It really varies.
Are there other costs besides legal?
Yes, definitely. You might have company secretarial costs for handling the filings. If you use specialist advisors to help prepare your CSSF advance assurance application, that's an extra cost. And ongoing costs for managing your capitalization table accurately.
Who usually picks up the tab?
The company almost always pays its own legal and admin costs. For investors, particularly angels looking at standard ASAs, their legal review costs might be minimal, or they cover it themselves. Sometimes if there's a lead investor like a VC putting in a significant amount via ASA, the company might agree to cover their reasonable legal fees as part of the deal, but that's negotiated.
What makes the costs go up or down?
Complexity is key. A highly negotiated, bespoke ASA costs more than a standard template. The number of investors involved, especially if they want different terms, increases cost. The choice between a law firm and a legal tech platform is a big factor. Sophisticated investors might require more negotiation or specific clauses. Needing CSSF advisors adds cost, and a big hidden one. If the company's existing corporate records are messy, the lawyers will charge more to clean things up before the ASA conversion can happen properly later. And it's really important to stress that the lower cost of an ASA is mainly an upfront saving. A lot of the legal heavy lifting and associated costs of a proper equity round are just pushed down the road until the ASA converts during that later priced round.
So it's not like the costs vanish, they're just delayed.
Largely, yes. You'll still need lawyers for the conversion mechanics, the new shareholders agreement, updated articles, etc. when that qualifying round happens. But legal tech platforms have arguably reduced the overall cost burden for these simple early-stage instruments compared to traditional methods.
When do these costs hit?
Throughout the process, drafting, negotiation, getting AA help, finalizing the ASA, then potentially more costs later for the filings after conversion and ongoing cap table management. Okay, connecting cost to speed. The other big selling point for ASAs is the timeline. They're meant to be fast. What does that look like in reality?
How much faster are we talking compared to a traditional equity round?
Significantly faster. Potentially, a simple ASA deal from agreeing the main terms to getting the funds could be done in a matter of days, maybe a week or two, especially if the company's corporate house is in order. Compare that to a priced round, which often takes weeks, sometimes several months, involving detailed diligence and negotiation. Platforms like Seed Legals really emphasize the speed aspect.
What are the stages and how long do they take?
Negotiating the core ASA terms like cap and discount can be very quick, maybe hours or a couple of days. However, the big variable is CSSF advance assurance. If that's needed before investors will commit, you're looking at HMRC's timeline, anywhere from 2 weeks to 2, maybe 3 months, sometimes longer if there are queries. That's often the critical path. Once terms are agreed and AA is sorted, if needed, drafting the actual ASA and getting the corporate approvals board and shareholder resolutions might take a few days to a week or so. Depends how quickly shareholders can act, if written resolutions are possible, etc. Investor review and signing is usually quick, a few days. Then the money transfer itself is typically fast, immediate, or within a day or two.
So for CSSF deals, that AAA waiting period is often the main factor determining the overall timeline.
Very often, yes. The documents themselves can be quick, but waiting for HMRC's nod can dictate the pace for tax-sensitive investments.
What speeds things up or slows them down?
Accelerators. Using standard templates, having terms agreed up front, having existing shareholder authorities in place, like that Section 551 authority to allot, using efficient written resolutions instead of calling meetings, responsive investors, and definitely having AA already secured. Delays. Bespoke terms, lots of investors wanting different things, needing to get that 75% shareholder vote for preemption disapplication if it's not straightforward, lengthy investor checks, though ASAs try to minimize this, HMRC taking time on AA, and messy company records that need fixing.
Who are the key players influencing this timing?
It's the company management, the investors themselves, the lawyers on both sides, HMRC for the AAR part, and crucially the company's existing shareholders for providing those necessary corporate approvals.
And this all happens within the UK legal framework.
Exactly. The practical timeline, especially for CSSF ASAs, is often a blend of document speed, corporate procedure time, and HMRC processing time. Okay, finally, let's bring this back to our audience, perhaps working in Luxembourg or elsewhere in Europe. How do these UK ASAs stack up against instruments you might see more often? Let's create some comparative context.
The obvious comparison point is the convertible loan note, or CLN. You mentioned the core difference earlier, but let's revisit that. Debt versus equity.
That is the absolute fundamental distinction, yes. UK ASAs, especially the CSSF compliant ones we've focused on, are structured as equity prepayment. Key features: no interest, no option for cash repayment, mandatory conversion into shares. The investor's money is treated as equity capital at risk right from the start. CLNs, as typically seen in Europe, or even non-CSSF UK deals, are usually structured as debt. They normally accrue interest. They often have a maturity date where the investor might get their cash back if conversion hasn't occurred. And crucially, the investor holds creditor status.
Meaning, in a downside scenario like insolvency, the CLN holder ranks ahead of shareholders.
Generally, yes. They're a creditor trying to recover their loan. The CSSF ASA holder, because they must convert into ordinary shares without preferences, ranks alongside the other ordinary shareholders. They share the equity risk fully. Their potential upside comes from the conversion discount or cap, and of course, those valuable tax reliefs, not from a debt claim.
So that CSSF requirement really forces a different risk profile onto the UK ASA compared to a typical European CLN.
Absolutely. It removes the downside protection that debt status and potential repayment offer. The UK ASA structure is heavily constrained by tax rules in a way that most European CLNs aren't.
Are there any European instruments that are conceptually a bit closer?
Well, sources sometimes mention things like the French BSA Air. It shares that goal of speed, deferred valuation, using caps and discounts, so conceptually similar in aim. But the UK still has those very specific, deeply embedded CSSF structural requirements that make it quite unique. Although there is a wider trend, noted by firms like Oric and Carta using market data, that suggests European markets are increasingly adopting more equity-like convertible instruments, perhaps moving slightly away from traditional debt CLNs for very early stages. It's also worth quickly clarifying some UK-specific things for listeners used to say Luxembourg law. That CSSF's advance assurance, remember, it's HMRC's non-binding opinion, but it's become a practical necessity to unlock UK angel funding because it gives investors crucial comfort on the tax relief.
And the term ordinary shares in the CSSF context.
Yes, it's not just the standard company law definition. For CSSF, it means shares issued on conversion cannot have preferential rights, no priority for dividends, on liquidation or redemption rights. The investor must take the same class of share as the founders or other basic equity holders, sharing the risks and rewards equally, different from how preference shares often work elsewhere.
And those UK company law formalities we discussed.
Key point for comparison. The specific statutory basis in the Companies Act 2006 for needing shareholder approval for directors to allot shares, 551, and especially needing that separate, often 75% majority shareholder vote to disapply preemption rights, S569571, when issuing shares for cash. These are distinct procedural hurdles compared to corporate governance in many civil law systems.
Plus the governing law itself being English common law.
Right. Contract interpretation relies on the specific wording, implied terms, and relevant case law, rather than a comprehensive civil code. Different approach.
This has been incredibly detailed, a really thorough look at UK ASS.
So, to quickly wrap the key takeaways, UK ASAs offer speed and flexibility for early funding by deferring valuation, but critically, their structure is massively shaped by the CSSF's tax reliefs. HMRC compliance is paramount.
Which means key terms are often non-negotiable. Non-refundable, no interest, mandatory conversion to specific ordinary shares, and that expected 6-month long stop for AA purposes.
Exactly. And getting that advance assurance from HMRC is often a practical gatekeeper for investment, frequently dictating the real-world timeline more than the document drafting speed.
They're fundamentally different from typical debt-based CLNs in Europe because they're equity from the start, driven by that unique UK tax landscape.
And understanding those specific UK company law steps authority to allot, disapplying preemption is vital for anyone advising on these deals, especially from a civil law background.
Okay, that really impacts the mechanics. Let's end with a thought for our listeners to ponder. Here it is. As UK startups look more internationally for funding, and as European markets perhaps adopt more equity-like convertible instruments, how will the very specific, tax-driven nature of the UK ASA interact with these trends? Will we see a convergence of structures across Europe, or will the power of CSSF keep the UK ASA as a distinct, somewhat siloed instrument? Something to think about. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.